All right, good morning. It is Tuesday. We are going to do the same format as yesterday as people present/share out their poster or presentation. After we finished an amendment, like Amendment 4, we're going to start with. I'll then share my notes and you can just write down notes I got. So we're going to start with our 4th. We're going to then do our 5th and then close with our 6th amendment today. So here we go. We're going to start with Ella, who made a little digital poster, and next you're going to hear Ella's voice. So here we go.
Fourth Amendment, Unreasonable Search and Seizures by Ella Stockman. This amendment actually says the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue. But upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. This amendment protects citizens and criminal suspects from unreasonable searches of their property and persons, and prohibits police officers from making unlawful arrests. In 1961 case, Mapp v. Ohio, the Supreme Court decided that any evidence obtained in violation of the Fourth Amendment would be deemed inadmissible in the court. Ohio convicted Mapp. The Supreme Court overturned the conviction and ruled any evidence gathered in violation of the Fourth Amendment is inadmissible. There's some snazzy pictures. Goodbye.
All right, nice job, Ella. We're going to move on to Abby, who also did the Fourth Amendment, and she's going to share hers too.
Bill of Rights, the Fourth Amendment by Abby Finnegan. The Fourth Amendment reads unreasonable search and seizures. To summarize this, it is the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Basically, it says, police can only search your home or property with a warrant or probable cause. The Fourth Amendment protects the rights of unreasonable search and seizure. The government can only enter property with a warrant or good reason. Warrants can be issued with probable cause. Your belongings, including your cell phone, can only be searched or taken with reason. You need a good reason to be arrested. Items can be searched at school if there is reasonable suspicion by officials or police officers. Supreme Court case, Minnesota v. Dickerson, 1993. When a police officer sees suspicious behavior and they think that criminal activity could be occurring, the police officer has the right to ask the person questions to determine if criminal activity occurred. Dickerson was frisked when he walked the opposite direction from the police when exiting an apartment building with a history of cocaine trafficking. The officer felt a lump in his pocket and believed it was cocaine. It was, and Dickerson was charged with possessing an illegal drug. The district court stated that the officer's seizure of the drug did not violate the Fourth Amendment. Minnesota courts of appeals reversed the case, stating that the officer overstepped their rights. Minnesota's Supreme Court also stated it was unconstitutional. During a pat-down, only weapons are allowed to be pulled from a person's pocket, and in this case, the officer did not believe a weapon was present in his pocket, and that is why this case was reversed.
Nice. So basically it sounds like Dickerson just walked by a police officer for just walking down the street, and the officer had him stop, and he frisked him. So that's kind of ended up why Court of Appeals and Supreme Court basically overturned this case. They're arguing the idea that they didn't have reason to stop him. So if someone looks shady, that's not necessarily a reason to stop a person. So if they're acting a certain way or doing a certain thing, that would give them reason. All right, looking at our Fourth Amendment. Fourth Amendment basically states, and again, remember, if you need to pause to write because I'm going quick, just make sure you pause it so you can get these notes down. But the Fourth Amendment is going to protect us, the people, from unreasonable searches and seizures. This goes back to the Revolution, when the British could come into our homes, take what they want, arrest who they want, for no reason. They had the right to just basically do whatever they want. So we made an amendment to make sure that we, the people, are protected from our government from ever doing that. When they say seizures here, by the way, they mean to seize a thing, to take something from you. That's what that word means. So that's why you see on shows and in movies that police must have a warrant in order to enter homes. And it also means that the government cannot take our property, our papers, or us, like arrest us, without a valid warrant based on probable cause or good reason. So when you look at police pulling over a person, for example, police do not have the right to seize or search any property without probable cause. Now, sometimes this could be a gray area. If you watch shows like Live PD or Cops from back in the day, both of them do a pretty good job of showing how a police officer analyzes a situation. So, for example, if a police officer saw smoke coming out of a car's driver is driving erratically, meaning they're kind of swerving all over, they almost hit other cars, they almost hit things, and that would be enough probable cause for the police officer to A, pull them over, because they could assume they're intoxicated from some kind of a drug, possibly something they've smoked. So that's why they would then stop them as an officer. So that would be one thing they would see as they approach the vehicle. Maybe there's a really strong odor of, let's say, like marijuana. And then third thing would be maybe the police officer actually sees a bag of marijuana sitting in the center, like cup holder of the car. Those are all reasons that the officer can have the person removed from their car, for one, place them under arrest or detain them, and then search their car. So those are all good examples of probable cause. So that's usually how a lot of it works in the least states where marijuana is illegal, for example. So, Fourth Amendment, however, does give you rights that help protect you in those areas. Here's a couple pictures here showing you an example of a warrant. Warrants, by the way, need to have like an approval of a judge. So it's not like police just get warrants easy. They actually have a judge's approval to basically there's enough evidence built up against that person that then the police can go to their house to arrest them and or search their house. So again, most warrants are not just made from thin air. They actually have to go through a process themselves. And United States versus Leon in 1984 would be another example of a court case. It took place in Burbank, California. And this is a police officer asking the judge. It says, "I would like a search warrant for Mr. Leon's house and car. I got a tip from a confidential informant that he has drugs at his house." And the judge says, "Well, I guess there's probable cause, Officer Rombach. Here's your search warrant." So it's a little joke saying that police, detectives, all FBI, anyone with looking to get a search warrant needs to have pretty strong and substantial evidence in order to have a search warrant be applied. So yeah. All right. Let us move on to our Fifth Amendment. Natalie was our Fifth Amendment, y'all. She forgot to put some audio up, so I'm just going to read it for her. In the Fifth Amendment is the due process of the law. And it reads, "No person shall be held to answer for a capital or otherwise infamous crime, unless on a presentment or indictment of a grand jury, except in cases arising in the land of naval forces or in the militia, when the actual service in a time of war or public danger, nor shall any person be subject for the same offense twice, but put in jeopardy of life or limb, nor shall be compelled in any criminal case to be witness against himself or herself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. They have the rights to read the Miranda rights to warn them of possibilities. All right, so the court case she has is from March 13th, 1963, with Ernesto Miranda was arrested from his home and questioned by police. They thought he was connected with the kidnapping and rape. Then the police recited a written confession. They hadn't advised Miranda of his right to have an attorney during the investigation, but after all, since Miranda did not specifically request this, his rights were not violated. So, guilty. Nice pictures, nice pictures. Okay. So what is the Fifth Amendment? Well, let's take a look at it. The Fifth Amendment is pretty straightforward. The Fifth Amendment protects us, the people, from being held for committing a crime unless we are properly indicted or accused. So we can't be arrested and charged for a crime without the proper steps taken by the police. That being said, you can also not be charged for the same crime twice. They call that double jeopardy. So in the case of, I think, O.J. Simpson from the late 90s is probably one of the most famous ones. O.J. Simpson was found innocent for murdering his wife, and like she was having an affair, or I think they were divorced, I forget. But he murdered his wife or ex-wife and the lover, allegedly, and he was found innocent. So later, he was taken to court again. He couldn't be tried for murder again, but they tried him on other charges like conspiracy and stuff. And I believe he ended up getting sentencing later for those things instead. All because he ended up stealing T-shirts, I think, from a store or something crazy. Yeah. Also, you don't have to testify against yourself in court, so you can plead the Fifth. They call that self-incrimination. And if you plead the Fifth, you basically don't have to testify. You don't have to be a witness against yourself. So even if an attorney calls you up and starts asking you questions on what you did, you can basically plead the Fifth. You don't have to testify against yourself. And that's our Fifth Amendment. The good example that Natalie gave with the Miranda rights, police have to read a person the Miranda rights. Otherwise, anything that they said or did prior to that point cannot technically be used against them in the court of law. That's why they say that. So Miranda rights, if you've never heard them, are you have the right to remain silent. You have a right to an attorney. If you can't afford an attorney would be appointed for you by the state, which would be a public defender. You have, anything you say can and will be used against you in the court of law. And I think that's the big stuff. So basically, prior to that moment, the reason why police don't say that is they're just kind of figuring out the situation. So anything you've said prior to the Miranda rights being given to you cannot be used in the court of law. However, generally, a lot of the things that were said before that, people then omit to or say after they've been read the Miranda rights, and that's why it's used in a court of law. So the reason why some criminals are getting trouble is after the Miranda rights have been read to them, they just say a bunch of stuff and do a bunch of stuff, and all that stuff is quoted and used in court. So, all right, moving on to our last two, which is our Sixth Amendment. And Nora is going to share her Sixth Amendment. Here we go.
The Sixth Amendment by Nora. The definition of the Sixth Amendment is, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and causes of the accusation, to be confronted with the witness against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. This ensures protection to the prosecuted person. They have a right to know their charges in a fast public trial. They also have a right to an attorney, and if they can't pay for an attorney, the government must provide one. They have a right to hear and ask questions to the witness testifying against them. Gideon versus Wainwright. Gideon was charged with a felony for breaking into a Panama City pool hall to steal money from the vending machines. He requested a court-given lawyer and was denied one, so at his trial he had to defend himself. He went to prison, and at prison he spent a lot of time in the library and talked to his inmate with a legal background. Gideon wrote a petition to the Supreme Court questioning the constitutionality of his case because he had not received a lawyer. The Supreme Court agreed with Gideon and reversed his conviction. Pictures, website. Thank you.
All right, good job, Nora. So if you saw there in Gideon's case, Sixth Amendment kind of ties into our Fifth Amendment. So let me go with Owen, and then we'll explain some more stuff. And here comes Owen.
Amendment 6. Right to a fair trial. What does the Sixth Amendment mean? This amendment guarantees criminal defendants the right to a public trial without any unnecessary delay, the right to a lawyer, and the right to know who your accusers are. The rights of the Sixth Amendment. The rights of the Sixth Amendment include the right to a public trial without any unnecessary delay, the right to a lawyer, the right to an impartial jury, and the right to know that your accusers have evidence against you. Gideon V. Wainwright was convicted of breaking into a Florida pool hall. He argued he did not have a fair trial because he had not been given a lawyer. The court held the Sixth Amendment's protection and provided him a lawyer.
All right, nice job, Nora and Owen. Gideon was the person both of you used. Nice. So, our Sixth Amendment, here is what it says. So, Sixth Amendment basically guarantees you to have a speedy criminal trial. So you can't be kept in jail for over a year without a trial. What we would have saw at the federal courthouse is often, a lot of times, it was actually a really cool process. We maybe would have seen this, maybe not. It just kind of depends on the year. But every morning at the federal courthouse, and right now I bet you a lot of it's happening over video because of the coronavirus, but every morning there's judges who actually have people who are arrested this morning at like 1 a.m., 2 a.m., 3 a.m., or late last night. They were arrested maybe at 6, 7, 8, 9, 10 p.m. And they are brought to the federal courthouse, and they are then scheduled their court date for their trial, and then they're sent to jail. So the cool thing about this Sixth Amendment, if you ever have to deal with this, I guess it's cool, but otherwise, is the fact that any time you spend in jail before your trial is taken off of your sentencing. So let's say you were sentenced to a year for, attempted robbery. Then you say you spent 6 months in jail before you went on trial, which probably wouldn't happen, but let's say it did. Then you would only serve 6 months beyond that. So you're still serving your year in prison, but you've already done 6 months. So also, you have the right to an impartial jury. Basically, that just means a jury that doesn't think you're already guilty. Let's say there's a police shooting. Lawyers will not have a jury that all hate police and think all police are killers, because that's not an impartial jury. That's a jury that's going to say the police officer's guilty regardless of the evidence. They're not going to hear it. Also, the accused can confront witnesses against them. So really, they can just know who is going to testify against them, so they can kind of ask them questions as well. And the accused must be allowed to have a lawyer. So if you remember the Miranda rights, you have a right to an attorney. If you can't afford one, the state will provide one for you. In a lot of cases, public defenders are thought to be like bad lawyers, and like some of the lawyers who like don't know what they're doing. At the federal courthouse, a lot of people there can't afford an attorney, so they have a public defender. And a lot of public defenders are people who do it for free, if you will. They're being paid by the government, but the people can't afford a lawyer, so they still have the right to a lawyer, which is what a public defender is. And the cool thing about the federal courthouse is the judges and those public defenders all have a passion for justice and helping people to have their rights protected. So that's contrary to what a lot of people think. It's actually not true at the federal courthouse. So, Sixth Amendment, though, you have a right to the speedy trial. Kind of going back to that, there's two parts to it. One, you can basically like demand to have a trial, but you also have the right to just make like a plea deal, which is like you just admit that yes, you did the crime. Generally, judges, because you're not wasting their time having a whole trial and a jury and all this stuff and all this evidence brought to you. If you come to a plea deal, oftentimes your sentences, are depending on the crime, are kind of reduced based on that. So if you more or less admit to your crime and you take a plea deal, you'll serve your time for X amount of days, and it really comes down to the judge's call and also your crime. I mean, if it's murder, it's going to be, you're going to get a long sentencing regardless. So, okay. That's the last thing we got for today. I've been kind of thinking about it. I think what I'm going to do, instead of having our Zoom meeting today, I'm going to try and get Mr. Madigan to come in, since he's a former lawyer and he knows a lot about law, so we can have a really cool discussion, including Mr. Madigan. So here's what I'm thinking. Instead of doing a Zoom today, I'm going to send out an email here shortly this morning, and we'll schedule our Zoom meeting for tomorrow. And that way we can have a general discussion about all the Bill of Rights. So I'm going to post a 3-2-1 for you to kind of reflect on what we've talked about today. And then we'll have our last 4 amendments tomorrow. And that will be it for the week. So plan to have a Zoom meeting tomorrow where we'll just talk in general about all 10 amendments. So again, I'm going to post that 3-2-1. You could put a question on there. I might post another questionnaire form again if you want to just add more questions you have. And that way it'll give us some starting points for questions tomorrow. All right, well, have a great Tuesday. I'm going to post CNN 10 with this, so if you need a brain break, if you haven't taken it already, why don't you take that brain break and have a great day. Bye.